15, I have filed an affidavit in reply against the affidavit in opposition filed by the respondent lordship. That may be permitted to tag with this case.
There is already a photographs.
That is referent lordship. This is reply.
With regard to item number 17, madam, by the earlier order, it was directed for a DNA test.
Huh?
A DNA test was directed by the
Item?
17, madam.
Report has come.
Oh, report hasn't come.
Report hasn't come. Madam.
Okay, right. As the trial court record with the DNA test report has not been received in terms of the earlier order dated 16/9/25. List the matter. Give it.
After Bihu.
May I please, I beg to mention one IF in criminal appeal manner for listing on Tuesday.
May I please, Your Lordship, I beg to mention for IA criminal on first week of January, madam,
Okay,
in criminal appeal.
okay.
May I please, the lordship? For listing the I for 21/1/2026.
Okay.
May I please, Your Lordship, my lord, item number 11, my lord, TCI is not yet received, man.
Yes, no WO also filed by you.
Yes, yes.
Yes, ma'am.
Okay, right.
11.
Item 11, you're right. As TCR has not been received, list the matter. The matter is adjourned till give a date. In the IA, you're right. Miss, who is going to pay? Mr. R.R. Kaushik is granted 4 weeks time to file written application. List the matter on same date.
I'm deeply obliged.
May I please, Your Lordship? With regard to item number 16, madam,
Yes.
I'm appearing for the respondent number 2, my lord. I am yet to receive the paper book.
We'll do it, I'll give you my copy. What will do? It is not objected. See the entire thing. He's a volleyball coach. He's not denied taking her here and there, they're staying away. Though, of course, he's denied that the most important part, but then it's quite clear.
Only. She had not there. And then they surrendered before it.
They surrendered before the police also.
In that case, madam.
Huh?
The POXO matter, madam.
Boxer matter.
Volleyball
The
coach.
volleyball coach.
May I please, Your Lordship? I beg to mention item number 18, my lord.
Yes.
In this case, my lord, medical report was called for, but
Madam, yet till now, madam, I have not received, but my friend morning stated that, madam, they may like to fix it for hearing also. Whether he's agree or not, I don't know.
When do you want?
after vacation, my lord,
Okay, right. Mr.
H. Ahmed.
H. A. Ahmed, learned counsel for the appellant, as well as Mr. R. R. Kaushik, learned PP, submit that the matter can be disposed of as paper book has been provided to both the parties. Mr. R. R. Kaushik also submits that the report with regard to the appellant's eye problem has not been furnished to him by the respondent till date. List the matter on, give a date.
Always.
May I please, Your Lordship? Will prefer against the judgment and order dated 22/7/2025.
What is your name?
Lordship,
What is your name?
Your name.
Manigali. My name is B. Islam, sorry.
Okay, right. Mr. B. Islam, learned counsel for the appellant. Prays for setting aside the impugned judgment dated 22/7/25 passed by the session judge come children court?
No damage, Lordship. Special judge, Lordship, damage.
Come children court. is it?
My lord, actually, these session judges, if I am not wrong, my lord, there is a notification. All the session judges on the concerned districts, my lord, they are also designated as children's court.
Under what provision of law?
My lord, in JJ Act, I think there is a provision.
Yeah, because petitioner was minor at the time.
Let us say Session Judge Dimaji. In special POXO case number 0624 arising out of Gogamuk PS case number 206/2021. By which the appellant has been convicted under section 4(1) of the Fifth Act 2000. Admit the appeal, call for the PCR. Issue notice returnable in 4 weeks. Mr. R.R. Kaushik, additional PP, appeals for the state. Appellant to serve, to serve a soft copy of the appeal petition to the office of the PP, who shall forward the same to the OC of the concerned police station. The OC shall thereafter serve the appeal to the respondent number 2 and make a report thereafter. This is the matter. You have it.
He was within 16 weeks. So he was sent to the court. Whether he should be considered a report given opinion, that's no, he should be considered as an adult and tried in the normal court. That is how we have. Very bad speaking. That's awesome, but that's wrong. They have not even taken a major plea.
So there is a IA also, sir, for sure.
Right, Mr. R.R. Kaushik. APP is granted 4 weeks time to file written objection to the application under section 430 BNS.
Much obliged.
This is the matter of, give a date, no?
May it please your lordship. Lordship may remember that matter, maintenance amount of rupees.
Lordship, we are filing objection today. It's under process here, Lordship. Let this matter come up on some other day.
Okay. The paper book has been made.
We-
So
we
we
have
can have the
received it.
hearing.
A paper book, my lord.
Paper book has been made.
No, only things, my lord, there is an IA, my lord,
That will do.
regarding suspension of sentences, my lord.
You
Paper
want
book,
to hear, you want to hear it now?
my lord,
You can hear it, no problem, if you want.
so subject to, because my learned friend said that for the IA, my lord, they are going to file an objection. She said that this is under,
Yeah, filed it, no?
yeah, he has filed.
It's under process. Today we are given to
Today
the
I
office to
filed
file.
5 eyewitnesses.
So your lordship,
They're filed eyewitnesses. These are all full of eyewitnesses are there.
all right, my lord, only thing, my lord, eyewitness, my lord, there are as many as 18 witnesses. We have been roped under section 149, adding 149, my lord. Only, my lord, Das, he is the person, he entered the home and there's a civil. Now, whether, my lord, we are for common object, my lord. See, my lord, there are two different things. One is common object and common intention, my lord. 149 rope other, one common object, my lord. The prosecution has to show the incriminating object, my lord, while forming the unlawful assemblies, my lords. And what are the act I have done in my lord, for the purpose of death of this the deceased, my lord. That is number one, my lord. If your lordship kindly see there, all these three people, my lord, they have been acquitted from the charge of 325 also, my lord. 149, 349. That meaning thereby, my lord, the 149, my lord, has been acquitted from the charge of 149, 325, my lord. So if it is 149, from the 149 we have been discharged, my lord. So how we have come under, my lord, 302, 149?
No, basically, no, I think under 325, okay. Anyway, that we'll see during the time of final hearing.
Definitely, my
There's
lord.
nothing here. This IA though we can dispose it of. We're not inclined. Yes, there are eyewitnesses and the small issues that the issues to go really into the merits of the case.
My lord.
I think we can, you might succeed in the appeal, as you say. But, at the highest stage,
my-
I don't think.
My lord, then your lordship fix the matter for final hearing, my lord.
We'll dispose of the appeal, we're not inclined.
My lord.
We'll, maybe you have got a case in the appeal. Otherwise, because if we hear you on this,
Only thing, my lord, your lordship has to hear on the point of 149, my lord.
correct,
Nothing more than that, my lord.
correct.
Only one person, my lord, as per the evidence of BW 6, my lord. She is the mother and she has requested because two of them has been acquitted, my lord. Two, my lord, if your lordship kindly see that Roma Borman and Ankur, Roma Burman kept hold the wife of the deceased, my lord, and she assaulted, she has been acquitted. Now, only this is Debo Burman, my lord, he entered by cutting the doors, my lord, he entered into the house of the deceased, and therefore he, inside what has happened, nobody knows, but the mother, that is PW6, PW6, my lord,
Hmm.
and 164 statement also of the mother, my lord, is there. There are two slight development of evidences while it's taking in an evidence. 164, I just show one thing, my lord. So a mother is concerned, my lord, 164 statement, my lord, which has been exhibited at exhibits, my lord, 6, I think, if I'm not wrong, my lord. What it says, 3, 4, 6, PW6, my lord. There,
Pushpa.
Pushpa Rani Singh. She happens to be the mother of the deceased, my lord. What she says, my lord, it is in
Page 190.
it is in a vernaculars, my lord. It is in a vernaculars.
But then, okay, read it.
No, substantive evidence is 164.
160. It is in vernaculars, my lord. So I have mentioned is
In
the
the paper book, it has been translated.
Uh,
Pushpa Rani Singh.
I don't have the paper book.
Page 190.
No, I don't have the paper book because a paper book has not been supplied. They moved the quality.
Do we have a copy? Give it to him.
190.
No, with you, man.
Around 11:30,
Yeah.
11:30 a.m. That is an 190.
Huh.
Page 190, my lord.
Yeah.
The 164, she is the eyewitness, claimed to be eyewitness and the mother of the deceased, my lord. What is she said? And she has been examined as PW6, my lord. Now, initially, my lord, her statement, which is recorded under 164, my lord, what it says, around 11:30 a.m. on the previous Sunday, my son was cutting bamboo in the courtyards. At the time, Bongsi Burman and Debo Burman arrived there and picked up a quarrel with my son over a cooperative lordship. Can you say Bongsi Burman and Debo Burman? We are not the society. Thereafter, Debo Burman's fathers, his younger brothers, Niren, Babul, Burman, Taposya, etc., along with some other individuals, came there and surrounded my house. Seeing them rushing at him, my son ran inside the house of the closed door. The Rajiv Burman brought a dog. Well, here it is, then Rajiv Burman, here it is a Debo Burman, my lord. It's not Rajiv Burman, my lord. Brought a dog whereupon, yes, my lord, Debo Burman cut the wall and entered in the house. I begged Debo Burman not to cut my son, but he pushed me aside, causing me fall in the veranda. Debo Burman hacked my son in my presence. In my presence, at that time, my daughter-in-law was at home. She was also hacked on the back and face of the dog, my lord. So it is Debo Burman, my lord. The dog has been given by Rajiv Burman and to Debo Burman, and Debo Burman cut the doors, entered there, my lord, and assaulted the deceased, my lord. That's what the mother of the deceased has stated.
And you
So
are,
now, Sobha, we are concerned.
who are you? You are?
We are what we are the accomplished.
What is your
As per
name?
the
What is your name?
my lord,
Your name is
Dhananjay Kaur, they are not
Dhananjay Kaur and
Tapos Das and Rajiv Das, my lord. So these trees are
Rajiv Burman and Rajiv Das are different.
different. This is the difference. They are not. Rajiv Burman gives the dao to my lord. Debo Burman, my lord. He cut the doors and entered, my lord. We are what I said, we are only, my lord, convicted in aid of 149, my lord. Regarding unlawful assemblies, my lord.
But this is
With
this is only 164. What is the evidence?
Yes, my lord, the lordship kindly see that evidences, if your lordship, evidence PW6 is
Yes, page 26, accused Deb Burman pulled Nandi Singh out of the dually and then caused injury to him by hacking him. The other accused person also inflicted injury to different parts of Nandi Singh's body. Page 26.
that what I have said it, there is a development of his evidences, her evidences. 164 is immediately at the time of occurrence, my lord. And while in the court, my lord, what says the other also inflicted, my lord. There is major contradictions. Kindly see EW 6.
Did you cross-examine the witness with regard to her statement made under 164?
My lord, that we but only think that examination are there. But if your lordship kindly see,
So how are you going to discredit the witness if you do not put that statement to her?
either way have a suggestions also, my lord.
No, you did not make any suggestion. Did you make?
My lord, what
Up
because,
to page 27.
my lord.
Nine.
Well,
So it is not there.
there is no suggestion, neither suggestion nor, my lord, any question has been put regarding
Then,
164.
then how can we take
My lord,
cognizance?
Only thing, my lord, if your lordship kindly see that the evidences, my lord.
That's why we'll see it during
In
the
hearing.
My lord.
See that time. That time we can go quite deep into it. Right
Because
now,
I do not have I don't get the paper book also. I have,
no, but you can see straight
yes,
away.
yes.
It's
No, I have seen now, my lord. I have seen, my lord.
so we'll for now we'll dispose of the IA and when do you want to have the hearing? When can we have a date? Okay, right.
Well, subject to, you know,
Now, Mr. P. Bora, Learned Senior Counsel. By Mr.
H.K. Sharma.
A.K. Sharma. Appears for the appellate. He has also been given a copy of the paper book today in the court. Ms. B. Buyan, APP, appears for the state and submits that she has received a copy of the paper book. This is the matter for hearing on. Huh?
no,
Hey, you're right.
12, I have some problem. I don't,
When? Some other date.
no, before that. Is there any date before or after what, 15? 17. Fine.
Mr. Heard, Mr. P. K. Bora. Learned Senior Counsel, assisted by for the applicant. This is an application under section 430 BNSS.
Rajiv Das,
Suspending the sentence awarded to the applicant pursuant to their conviction under section 147/148/449/149 IP. While the ensuing judgment dated 13/12/24 passed by the learned sessions court Demaji in session case number 106 of 2013. The applicant's counsel submit that the PW, what is that PW?
Six.
The PW6 has developed a statement made under section 164 CRP. In as much as the applicants here were nowhere mentioned by PW6 in a statement given under section 164 CRP. On the other hand, Ms. B. Buyan, additional PP submit that that PW6 has not been cross-examined and given any suggestion with regard to any development being made in her 164 CRPC. As such, the plea of the applicants cannot have any fault at the stage of considering an application under section 430 BNS. As the only requirement of the court is to have a prima facie case, correct?
Yes, yes.
That whether the applicant was guilty of having committed the applicant on considering the fact that no questions had been, considering the question, and considering the fact that the applicant had not put the statements made under 164 by PwC during her cross-examination. And as there appears to be many eyewitnesses, and there are many eyewitnesses to the crime in question, we are not inclined to allow the present application at this stage. The application is accordingly rejected. Any observation or finding? No, we have not made any observation or finding with regard to the merits of the case in this order. And any findings or observations that may have been made will not be taken to be the final observation or findings at the time of hearing of the appeal. As accordingly disposed.
May I please, Your Lordship? We are newly engaged in for accused number 3, my lord, Rajiv Das.
Rajiv Das.
Yes, my lord. They are together only, my lord, but we are newly engaged in that.
In the IA, are you there?
No, my lord.
Then
We'll be filing Kalama today itself, my lord.
you have to file a separate appeal.
Yeah, but the matter was
No,
together only, my lord.
No, Belek is separate.
So he's
Cross
only there.
different.
He's only there.
We have not
No,
filed
Aren't you
Kalama.
there for Rajiv Das also? What is this?
My lord, what has happened, they have taken my brief from me, my lord, the last one. They have,
Rajiv Das.
he
They have-
has taken, my lord,
Okay, right.
and engaged Mahajan.
In the appeal, you're right. Mr.
D. Bora, my lord.
D. Bora
My lord.
submits that he will be appearing for the appellant number 3,
3, Rajiv Das.
Rajiv Das. And he has taken the consent of Mr. R. Bora.
P. Bora.
In this regard. Mr. P. Bora also submits that consent has been given.
God bless, my lord.
And then you take the photocopy from them.
Yes, ma'am.
Make a photocopy.
Yes. God bless.
What happened to the respondent number 2?
Your Lordship, I have taken steps, and also there's a order which says that it has to be taken through the PP, Your Lordship. The registry is supposed to.
My lord, I have not received the instruction yet, my lord.
Okay, right. Mr. R. Kaushik, learned APP, submits that he has not received any instructions with regard to whether notice has been served upon the respondent number 2. It is also seen that no TCR has been received by the registry till date. Accordingly, list this matter.
After vacation, my lord.
Give a date.
Take me now.
And how much time for the written objection?
My lord, same day I will file. In fact, my lord, DCR has not received, that's why we have not received the paper book also.
Naturally, but you don't need for written objection. Where do you need? Why
My
do
lord,
you
I will
need-
file that day, my lord. Okay.
What are you going to say? Everything, normal thing you're going to say.
My lord,
You just read it from the judgment.
my lord.
Obliged.
All right,
70.
Mr. R. watching the eye, yeah?
18.
Is
18.
granted 4 weeks time has been objected to the application and the second, 4:30, the end is the matter of the matter. Give it. Note here,
No TCR.
no,
No TCR. And documents were of course served to me, but TCR is not yet.
okay, right. What about respondent number 2?
ऊपर तो कागज ही नहीं मतलब डॉक्यूमेंट की नहीं
Lordship, no papers available with us.
No notice was issued to the respondent number 2, it appears. Huh? The order for impleading respondent will be passed after the recordal. No, no, why? Oh, okay.
because lordship in the papers it cannot be deciphered what is his address lordship.
Okay, okay. Okay, you're right. No TCR has been received by the registry. In terms of the last order, respondent number 2 was to be impleaded after receipt of the TCR. To ascertain the address of the respondent number. Next one. List the matter on, vividly.
Obliged.
Seven also similar, my lord. In fact, the address of the respondent number 2, my lord. The victims, my lord, is not known. Therefore, the LCA was called for.
Okay, right. Same one. No, outside, okay, outside PCB, the outside the TCR is there.
Oh, this is.
Let us see the address of the phone number. Right, out there. As TCR has been received. From our registry to prepare the paperwork. In terms of the TCR, the address of the informant, with the FIR. The address of the informant, what is the name? Saraswati Bhumij. 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 Wife of Kartik Bhumij.
Wife of Kartik Bhumij.
Give it to me. Page 51. You put it there, put that. I put the two blue.
Durali Village, Jinjia.
Application.
Swati was most of
No, correct. So you're right. Accordingly,
Achi order private. Here,
you are
Jinjia.
the appellant. Am I correct?
Yes, sir, for that.
Accordingly, the registry is to provide a soft copy of the appeal petition to the office of the PP who shall furnish the same to the OC or officer OC of the
Jinjia Police Station.
India Police Station. In as much as the matter pertains to Jinjia PS case number 15 of 2024. List the matter given.
We'll do the needful.
Huh?
Lordship will do the needful.
Registry will provide you.
Through us, my lord, will.
Yes. Same thing.
Apply your lordships.
19-2. Lordship, here learned counsel J. Das is no more, my lord, so someone is to be appointed. my lord. You have so process tips, sir. Okay, no problem.
Correct. As TCR has arrived, registry to prepare the paperwork. It has been submitted that Mr. J Das, the learned magistrate curate, has expired. Accordingly, who do we appoint? Who? Accordingly, Mr. Nilanjan Deka is appointed as the magistrate. This is the matter. After give a date. February, January. Item 9.
May I please your lordship? My lord, LCR not yet received, my lord. And my name was also not shown in the for this, my lord.
Okay. Miss PB Bordola.
Yes, my lord.
You're the legal aid
Yes, my lord.
appears for the appellant. No TCR has been received. Stop. Further, what about notice, madam?
For the first time it has come.
No. Yeah, already.
It has been condoned.
No, this is the second time. Orders of 1911 Justice Surana has already passed on. It has been notice already issued on, is returnable on 15/12 on 1911.
So we'll take fresh steps.
Okay, yes, notice issued to you already. Ms. B. Buyan, additional PP shall obtain inspection with regard to whether
Not a short date be granted,
On
but
the-
we'll do the needful.
upon the respondent number 2 to the OC of the concerned police station. List the matter. Give a date. The Miss no, the registry to reflect the name of Miss PB Bordoloy, learned legal aid in the causes.
Highly obliged.
Borkhola. Here service report has come, my lord. Notice was served. Informant was not available, it was served on her husband. Report is given to the deaf. From Komarbanda OP, under Golagat PS.
FIR page number 19, lordship annex are in.
Objection time.
Yeah, right.
Disse copy? Photo disse?
As TCR has arrived, registry to prepare the paperwork. Ms. B. Buyan, APP has submitted letter dated,
It's a report dated my.
no,
14/12.
report dated 14/12/25, issued by the in charge Kamar Bandha OP, stating that notice has been duly served upon the upon the respondent number 2, is it?
To her husband. In the presence of Rao
Number
Burha.
2 through her husband. So accordingly, notice deemed to be served upon the respondent number. This is the matter after 4 weeks. Then in the I, right, Ms. B. Buyan, APP is granted 4 weeks time to file.
We have already filed.
Yes,
Fine.
already
Yes, no?
filed, fine.
Oh, yes, you're fine. Oh, yes, you're fine. Yes,
Letter
Yes.
come only yesterday, copy was served.
Your lordship, I will release on bail as because there is a
What is there out here? This is a
Ground-
POCSO
ground
matter,
counsel
section
have-
book is there.
My
Will
lord,
decide,
complication is that, my lord, there are two convict appellants, my lord.
huh?
Two convict appellants are there, my lord.
So what? Very, very.
Lordship, occurrence at the daytime, Lordship, at 9 or 10 p.m., Lordship. Prosecution failed to establish the fact that, and she was in a Lordship drunken condition. Victim was in a drunken condition.
No, my lord, in her postmortem report,
It-
there are no trace of alcohol, my lord. I have not found anything, man, in her.
But it is the evidence of the witnesses, Lordship, on which a learned trial court relied. PW 3 and 4, Lordship. 3 is the mother and 4 is the daughter.
You see, your daughter, your 10-year-old daughter
Lordship.
saw both of you fighting. So she got scared. She ran to her grandmother.
No.
When they came back, their mother had died.
That is true.
Who hit her?
Lordship, but both of them are in a drunken condition.
So-
That's why
Ah,
my submission is that whether on the basis of that evidence, conviction can be sustained.
why not?
Lordship,
Why not? 106 Evidence Act.
Lordship, I'll submit in favor of my Lordship argument. I will rely from the judgment, Lordship, that I will submit. But today time is most
It's very simple.
Lordship.
You see, it did not even take time for her to just go and call her grandmother when she came back.
It is
Yeah,
about
she's
half
the-
an hour, Lordship. From her evidence, it is half an hour. Lordship, evidence of PW4.
FIR lodged by whom?
Mother, Lordship.
Mother of whom?
Mother of the accused.
Mother of you. Your mother filed a FIR.
Lordship.
Against whom?
Against the son. That may be, but Lordship, whether there is any evidence to sustain conviction. That is my submission. He is a prime suspect, that is true. But whether legally there is any evidence to sustain conviction, that is my humble submission. Lordship,
You've got to explain how your wife died. How did your wife die?
only it is after when prosecution succeeded to establish the fact that there is no other.
According to us, they have succeeded.
But how, Lordship? There is a
Your
half an hour, Lordship. That time, if third party enter, daytime, it is not that room was closed and incident occurred within the room. That is also not, Lordship.
You see,
And
because your daughter has said, your 10-year-old daughter has said that she saw both you and your mother fighting. Both father and mother were fighting, and accordingly, I went from the house to inform my grandmother. When I reached home, I found my mother lying unconscious on the ground. So what happened? After fighting, you suddenly went out. Oh, what happened? You went and made tea.
no,
what?
I'm not on that. I'm on that. Both of them are in a drunken condition. Whether there is a possibility of entering third party,
But
that
the
is
burden lies on him, my lord.
Yeah, that is the thing.
Burden lies on
It is on you. You have got to explain what happened.
but
Actually, what happened?
daytime, Lordship, he is in a drunken condition.
Oh, he
Not
doesn't know
making so.
anything. He doesn't know anything.
Lordship,
Doesn't remember according to you.
Lordship, that is my Lordship, and I am also relying on one of the judgment, Lordship.
Please.
what your lordship is stating, my lord, and if your lordship kindly peruse page 23. My lord, here there are multiple breaches also, and both are front side, back side. So she can fall in one side, not in both sides, my lord. And regarding this,
She can roll down the steps.
my lord, no, there's
And if you roll down the steps, what will happen?
no, this
You
is not-
cannot keep on, one side you cannot keep on falling one side only, jumping. And very.
Yes.
he wrote
Inside the
down-
house, my lord, there's.
Lordship, page number 3, kindly have a look.
Yeah. Yes,
Lordship, it is no doubt that while the first part of the section speak of intent to knowledge, the latter part deals only with the knowledge and certain element of doubt. Interruption may possibly be left by means of this omission. It is voluntary to darkness knowledge is to be presumed in the same manner as if there was a no drunkenness.
whether there was no drunkenness, okay?
Lordship, what about those cases where mens rea is required? Are we at liberty to place in? Nothing.
Look, Mr. Counsel, look, offense requiring a particular intent or knowledge.
But the general
Regarding when a person is intoxicated,
Lordship.
it only applies when the thing which intoxicated him has been administered to him
Lordship,
against his knowledge and against
Lordship,
his
it is
wishes.
in general exception under IPC, but it is the judgment of the apex court, Lordship.
How does this help you? I don't know.
Lordship, in this case, Lordship, Honorable apex court taken a different view, Lordship.
No?
Lordship, look at.
You see, the question of intention it may be interpreted differently, that's all. But the fact that you had committed the crime is not in doubt.
But here he
And this also doesn't help you. Very difficult case. You see, it's very simple. The only thing is that you have got to give an explanation as to what happened to your wife. Unless you say that you were too drunk and you did not know. Is that okay?
Oh, yes, Lordship, in his 313 statement, Lordship, kindly have a look.
Yes.
His 313 statement. He denied.
And what did he say was the reason?
Lordship, I'm taking a Lordship, his statement. That start from page Lordship 24. Question number 2, Lordship, have a look.
Come to question number 3. Yeah, 2, yes, 2. Read.
My wife, Lordship, question number 2, Sri Taposh Biswas is given evidence as PW2 against you that you used to fight frequently with your wife. You are his neighbor.
Neighbor.
You are his neighbor. At the time of occurrence, incident, police called him, and when he went to your house, he saw that your wife was grievously injured and was almost about to die. Then he carried your wife to the police vehicle, and police took your injured wife to the hospital. Later, your wife died. Are you responsible for your wife's injuries? My wife was drunk and she fell down and sustained injuries.
So
It is his plea.
Yeah.
It is his plea. But his daughter also, Lordship, stated that wife was in a drunken condition.
Correct.
Doctor, Lordship, now your Lordship kindly come to evidence of the doctor.
So one thing is clear. From your 313,
Right.
you saw her fall down and sustained injuries. That is what you have said. She fell down and sustained injury.
She fell down, but
But what?
fell down For that, whether accused can be, appellant can be, Lordship,
I'm not saying anything. This is what you're saying.
no, Lord.
You have said she was drunk, she fell down and sustained injuries.
Thank you.
That is, you saw her fall down. You saw her sustain injury.
Okay. And doctor's opinion, Lordship,
That is the
kindly.
doctor's opinion.
Ah.
23.
Yes.
Cross part, Lordship, page 23. Cross part, Lordship.
Yeah.
So from the evidence of the doctor as well as Lordship from the PW4, whether a inference can be done to the extent that only accused appellant is committed any
I don't
murder.
know. You were the one who saw her fall down. You were the one who saw her sustain injuries. Now you tell us, was there any person in the room? We don't know. Only
No,
you
but
know.
from his statement, if your Lordship believe that
I believe in you. We want to believe you. Please tell us a good story.
Lordship, but story is there on the record. On the record, Lordship. That's why I'm relying on the record. I am submitting, Lordship. I have to point out as a amicus curiae, I am not in this case as an engaged lawyer, as amicus curiae to assist your Lordship. That's why I'm pointing. But from this, it is in fact that he has seen. Question answer from the answer of the question number 2, it can be in fact that he has seen.
No, why should we infer when you have given your explanation under 313 that you saw her fall down and
But he category once he has stated that he fell down, that means he has seen.
yes, correct.
It is.
Yes, yes.
It is seen. It is seen.
So,
Can't
has-
say.
So once he has said that he has seen her fall,
Yes.
why didn't he say about some other person being there?
No, that was not he stated. It is true. It was not stated. But it is, I am arguing on that point, whether conviction can be sustained based on this evidence, whether prosecution has established a case beyond all reasonable doubt or not. I am submitting, I am raising the point, Lordship will adjudicate. So,
That's all.
Lordship. And other thing, Lordship, another judgment. Lordship, these two. Para 13, Lordship.
Yes.
Para 13, page 412. Suspicion, however grave it may be, cannot take the place of proof. And there is a large difference between suspicion. He may be prime suspect.
So
but
according to you, there has to be an eyewitness in all cases.
that is not. But whether in the circumstantial evidence, it is there is only one inference. There is a possibility of fall and Lordship. That's why I'm submitting on.
Correct. Okay. That's all.
Here, Lordship already pointed out section 106 method. I will not again say on that point. Second, my lord, section 6 of evidence act doctrine of res justitia. From the deposition of other witnesses, it seems, my lord, they used to fight regularly. His conduct prior to the occurrence and after the occurrence. The section 6 will come. My lord.
Lordship, May I take your lordship? I have submitted a judgment, past judgment.
Uh-huh.
Your lordship may kindly come to page 3 once again.
Huh?
Page 3 once again.
3 years?
In a charge of
Murdering a child.
no, lordship, above. Weapons, but where a dangerous instrument is used, which if is must produce grievous bodily harm. Dankness can have no effect on the consideration of the malicious intent of the party. But here it is in this case, lordship, it is the evidence that a stick of wood was used. It is stated by the PW 4 in her 164, but in her before the trial court, in her evidence, before deposition, she is silent on this point. Only quarrel, intoxicant, this was she stated. This aspect also lordship may consider.
Already,
Huh?
section 6, I have already stated, my lord, his conduct, doctrine of res judicia, that will come. Third, my lord, he has taken the plea, my lord, friend, that he was under intoxication, my lord. That general exception only come when it is involuntary. Voluntary intoxication, he cannot take the benefit of that general exception. Third, my lord, this regarding the victim being intoxicated, that has not been proved. Maybe the child, she stated, because they used to fight regularly under the guise of intoxication, my lord. So she might have, my lord, comprehend. But the postmortem report, if she was intoxicated, there must have been some residue of alcohol, my lord. That is not found in the postmortem report, my lord. And my lord, page 23 and page 22, my lord. First, my lord, external appearance, wounds, position and character, multiple bruises present on the face and lower limb, both buttock, thigh, leg. One laceration present on the right leg, size of 1 centimeter into 0.5 centimeter. So there are multiple injuries, my lord. As lordship pointed out that there may be staircase, but from this, my lord, page
Maybe he bounced down the staircase only one side.
76, my lord. This is a single hut type house, my lord. So, my lord, that possibility is also not there. It's not that she is falling from first floor to second ground floor, my lord. So these are the injuries he has to explain, and 106 he has to explain what happened. He's taking the plea that third party came, my lord. How came, when came, it's up to the accused, my lord, under 106, my lord. That he has not discharged.
Okay,
my lord.
that's all.
That's all, my lord.
Lordship, in reply to my learned friend's argument, one thing, all the witnesses stated both are in a quarrelsome relation while they are intoxicated. That aspect is there. All the witnesses stated. It is the prosecution witnesses who stated so. And other aspect, lordship, once again kindly come to your lordship. I am again taking your lordship to judgment that I have given at the first instance, Supreme Court of India, Vasudev versus State of Persue, page 3. In that case also, it was a case where husband and wife murdered their child. Lordship, I am again pressing on this point. In a charge of murdering a child leveled against a husband and a wife who are both drunk at the time, Patterson J. observed in Regina versus Pro such and such, it appears that both of these persons were drunk. Although I am not pleaded the general exception, lordship. General exception not applicable in my case. But this is a decided case. I am basing on drunk, and although drunkenness is no excuse
you see,
for any crime,
this judgment,
lordship.
it only pertains to the crime is committed.
Oh, yes.
But whether intention was there may not be proved. That's all. So that's all. So so what you're trying to say is that
Look.
it is culpable homicide not amounting to murder. That's why 304 part 2 maybe apply. That's all. That's what you're trying to say.
Lordship,
Correct.
Lordship. But in this case also, Honorable Apex Court also taken a similar view, Lordship. That's
Correct. Because when you are so drunk
Lordship.
that you cannot have an intention also to do it, but you're just, mechanically doing things. So intention to kill might not be there. But then that does not take away the fact that you have knowledge that some harm is going to be caused to that.
Lordship, but as a Lordship,
Got it,
defense
got-
where I have to raise, this is the Lordship, but it is Lordship will decide the issue.
What we
Adjudicate-
say, anyway, there is 106 is there. Heard, Mr. Mazumdar,
LR Madhukar.
Learned L.R. Mazumdar, learned amicus curiae, appearing on behalf of the appellant, and Mr. R.R. Kaushik, learned APP. Hearing concluded, judgment reserved.
One piece of wood button was also recovered.
Huh?
One piece of wooden button.
Seized.
madam.
Seized and exhibited.
Seized, madam.
Bottom,
Button,
bottom.
madam. BAT.
Wooden stick, Lordship,
Sting.
that is in the obedience of the PWs.
That was not sent to FSL.
Not sent.
Not sent.
Anyway, there is.
Even if they sent,
Lord-
there is no report.
One more submission that may be altered. Lordship, that sentence,
We'll see.
Lordship.
But we have to see that you were very, very drunk. You have to be very, very drunk. To the extent that you were not able to to have an intention to kill.
Lordship.
So you have not proved that you were very, very drunk.
But drunk is proved, but very, very drunk, that is not there in the record, Lordship. That may be considered, Lordship. Otherwise, he has a daughter, Lordship, minor daughter. Of like,
Yes.
Your Lordship. Lordship,
There is a correction required.
yes, yes.
Any
please.
objection, madam?
No.
No. Okay, heard.
Dipshita, Didas.
Didas, learned counsel for the applicant, who submits that a typographical error has occurred in para
Para 4. Sorry, Your Lordship, in para 8.
in para 8 of the order dated 27/11/25 passed in WPC 5633 of 2020. She submits that the year 2002 mentioned in para 8 should be read as 2005. Full stop. Next para. Miss,
On behalf of SK Talukdar, sir.
your name.
Arunima Das.
A.
Das.
Das,
Gidas.
appearing on behalf of Mr. R.K. Talukdar.
SK Talukdar.
S.K. Talukdar, learned counsel for
Elementary Education.
Elementary Education Department and okay, submits that she has got no objection to the application being allowed. So stop. Next para. In view of on considering the prayer of the applicant's counsel, this court finds that mistake has occurred in para 8 of the order dated 27/11/2020. So stop. Accordingly, the year 2002, invert comma, 2000, which is reflected in para 8 of the order dated so passed in so should be read as the year, invert comma, 2005. The I is accordingly allowed and disposed of.
Lordship, if I may. Your Lordship, I'm appearing on behalf of Mr. Fukan.
Okay, appearing on behalf of Mr.
Mr. Fukan.
Only
RB Fukan.
Fukan, RB Fukan. The necessary correction may be made to the Impugned order, correct? I is accordingly allowed in this book.